Good evening, everybody. Hope you're all doing well. Today is Wednesday, November 12th, 2025. And again, I hope everybody's doing well. We certainly had some cold weather here in the Atlanta area. It is warming up a little bit, which is very nice. I'm hoping that will continue to warm up because I'm not a big fan of cold weather. Had a nice weekend. My wife and my daughter played in a city championship for tennis, and they won. So that was kind of cool to see them get there's a pewter plate that they got. So they were very happy about that. And, it's always kind of fun to win. It doesn't happen that often that your team does really, really well. So we were very pleased about that. So as far as Social Security, I know that a lot of people have been asking about the possible changes to Social Security in terms of the new laws. And what's been talked about has been possibly changing Social Security disability to eliminate age as a factor, possibly to eliminate or reduce the grid effect of the grid rules. That has not happened yet. The sense I get from talking to some of my colleagues is that if they do make a change like that, first of all, it'll be published in the Code of Federal Regulations and put out for comment. So certainly if that happens, I'm going to let everybody know. You should post a comment and basically say that age should definitely be a factor. That's one point. Second point is that, even if they do, quote unquote, eliminate or reduce age as a factor, my sense is that many judges will continue to consider age because they realize that a person who is 57 or 58 years old, it's going to be very difficult for that person to make a change from a physical labor type of job, let's say construction or warehouse work, to go to a sit-down office type of job, especially if they don't have computer skills, which of course is what the grid rules are all about. So again, somebody with a high school education who's done, labor work, again, warehouse, truck driving, forklift driving, things like that, going to be kind of hard for such a person to get into an office environment. I think judges know that. So I don't expect we're going to see a real practical change. But again, we'll have to wait and see. Again, at this point, nothing has happened. I keep hearing it's going to happen in November or December. We're halfway through November. Nothing has happened yet. So that's all good. Let's go to some of the comments here. Cynthia says, good evening to everybody. Good evening, Cynthia. Hope you're doing well. Bala 2001. Hello. How are you doing? I think I know who that is. Let's see here. Focused Lady says, greetings from Ocala, Florida. Congratulations for the well, it wasn't me. I mean, the only thing I did was I played in my own league. This is a women's league. Actually, the mixed team is going to start in January. I've got a really good team, so I'm hoping we can do something. My men's team didn't do quite so well this time, so we kind of had to live through the glory of my wife and my daughter. But we do all practice together, so we worked and I hit the ball pretty hard with my serve, so I worked with them hitting the ball really hard, and they get it back, and I think that did pay dividends. But they deserve all the credit. I mean, certainly, I do what I can to help them, but they did the hard work, and it was definitely some really, really good tennis, really high-level tennis being played. And my wife is, in her early 60s, and she's rocking and rolling. She's really, really good. So it was fun to watch. But thank you. Dimple says, hello, Dimple. How are you doing? All right. So good question. How do the new changes, again, we don't have them yet. There's been talk about it, but so far it has not come about. But if it does, obviously we will address it. If you are over 55 on SSDI and the age for retirement, well, the age for retirement right now, early retirement is 62. I think full retirement is 66 or 67. And then the extended retirement is 70. So I've not heard anything discussed about changing the retirement age, although it wouldn't surprise me if that becomes something that's up for discussion. But right now, and my guess would be if they did that, it would only apply to people currently, let's say 50 years or younger. I don't think they're going to change the retirement age for someone who's 61 and who's thinking they can early retire at 62, and then all of a sudden they get a letter in the mail, we changed it to 64. I don't think that's going to happen. I think they're going to only make any changes to retirement for people where they've got enough time to kind of plan for it. Also, with retirement Social Security, you have the AARP, which is a very powerful lobbying organization. Their focus is on Social Security retirement. They sometimes comment a little bit about the disability, but for the most part, it's about retirement. So I don't think that there's going to be a whole lot being done to retirement. But the question is, and this is a question I don't have an answer to, let's say they change it and eliminate age as a factor, and you've been approved under the grid rules. Will you get a CDR that says, well, now the rules have changed, you're no longer disabled? My experience has been, if they do make a change, then a CDR would, use the new rules. So that certainly could happen. I think there's certainly a desire in Congress to eliminate people from the disability rolls. So it is certainly possible that if the rules are changed, that it would be effective to people who are already getting disability benefits. I still come back with, if you're over 55, the odds of being reviewed and terminated are pretty low. I think where we're going to see continue to see CDRs are with people who are, in their 30s and 40s, who've got another 20, 30 years to be drawing against the system. So that's my thought. I don't think it's going to really affect people over 55. People 50 to 55, could come into play. If you won a case on the grid rule at 52, you were limited to sedentary work with no transferable skills, and you were approved under the grids, and now you're 53 or 54, and there's new rules. They could review you on that. So that certainly could happen. But again, it's too early to tell. We don't know yet. But that would certainly be something that would be of concern to me, which basically says continue to go to the doctor, continue to seek treatment, assume that you may have to defend what you've been going through down the road. I will tell you that, and again, it can all change, but generally a change this big, I don't see this happening in, I don't see this happening in, 3 or 4 months. My guess would be that, normally if they make a change, it would be effective in July of 2026. This one I see probably more like December of 26, if it does, because not only do they have to change the rules fairly substantially, there is some question about whether Congress would have to do it, or can the agency do it on their own? We don't know. The second thing, and it's probably even more important, is Social Security has been using an outdated vocational tool called the Dictionary of Occupational Titles. You can visit it at occupationalinfo.org, the DOT. The DOT lists every job that theoretically exists in the economy. The problem is it was last updated in 1993. So there are, of course, jobs in the DOT that no longer exist. I mean, I think you could be a typewriter repairman. Well, there are no typewriter repair people at this point. There's no jobs, or certainly, that you can count them in the 10s or 20s, or not hundreds of those jobs. Other jobs, and you give this example before, you're a copy machine operator. Back in 1990, them and walking up to a copy machine, putting a piece of paper, hitting a button, and taking the copy. Now you put a piece of paper in the copier, you scan it to a computer, then you go to the computer, you have to download the scan, you have to rename it, save it to a person's folder. It's a 5 or 6 step process, and it's not really unskilled anymore. So I think that the DOT would have to be replaced. There are some candidates for it, but that's going to have to go through some testing. They've tried to do that before, nothing has happened. And my sense would be, before they make a wholesale change, they're going to have some other source of vocational data, because right now the courts have been fairly deferential to Social Security in allowing them to use an outdated resource. If they make this substantial change and disqualify a lot of people, I think that the courts are going to be a lot more hard line on Social Security to say, we're not going to let you use these outdated resources anymore. So, I don't have any inside information. My guess would be, if they make a change, it goes through the comment process, there's going to be restructuring. It would probably be, in late 2026 if this change goes through. I hope. I mean, if it was, it'd give us plenty of time to prepare for it. If it's July of 26, I think there's going to be a lot of litigation. So I'm hoping that won't happen. I'm hoping that they'll get, I think sometimes in this current administration, there's a little bit of ADD going on. I think that they may find a shinier target and maybe move on. So we'll see what happens there. But I do think it will eventually affect people in the CDR situation, which is obviously not a good thing, but that's what's likely to happen. Aurora Sanchez, thank you for the info. You're very welcome, Aurora. I hope that you found it useful. I did record, by the way, a bunch of videos the other day. Right now they're being edited. We'll get those out. I've really tried to, this year has been really, really busy in terms of hearings. So I haven't done nearly as many videos as I'd like, but I did some videos. One of them, for example, was about the change in the numbers for substantial gainful activity. In 2025, I think it's $1,620 a month as SGA. In 2026 will be $1,690. So basically what that means is that in 2026, starting in January, if you're earning less than $1,690 a month gross, you would not be considered to be performing SGA or substantial gainful activity level work. And that's over $20,000 a year. So in other words, you could have a part-time job or a full-time job for that matter, earning $20,000 a year and not be considered to be working or being at SGA level for Social Security. So that means when you're struggling to survive during the 2 years it takes to get to a hearing, you can have $20,000 a year coming in. Obviously, that's not a ton of money, but it's better than nothing. And one of the things, and it's another thing I talked about in one of the videos, a misconception about Social Security disability is that you're not allowed to work while you wait for your decision. Absolutely not true. You can work again in 2025, 1620. In 2026, it goes up by $70. So I think that you certainly can work. Now, I don't think you ought to be working real close to the limit. I think if you're earning $1,500 a month every month, Social Security might look at that and say, well, you're intentionally suppressing your income. But on the other hand, if you're $1,000, $1,200, $1,400, I think most judges realize people do have to survive. So I don't think that's as big of an issue. So anyway, that's one of the videos I talked about, is that change and the change in the trial work period numbers. They've all gone up to make it a little bit easier to do trial work without jeopardizing your benefits, or to work while you're applying, or work after you've been approved without jeopardizing your benefits, which is what this is all about. Realize they want to get people back in the workforce. That's their goal. So giving you opportunities to try to work without jeopardizing your benefits is one way they do that. And I think that's a positive for everybody. Roy 777 says, if an autistic person is working full-time and can't do it anymore, can they still be eligible for SSDI and work part-time? And again, this is exactly, Roy, what I just talked about. Yes, you can. The question is, what would your gross earnings be? And if you are earning $1,620 in 2025 or less, not a problem. If you're earning $1,690 in 2026, not a problem, or less. Unless your earnings are really, really close to the limit, and it looks like you're intentionally suppressing it. I think Social Security struggles with a balance between encouraging people to go back to work and not letting people, kind of, I hate to call it game the system, but to work right to the limit when it appears that they're intentionally keeping their earnings below a certain level. There is some thought that might trigger a continuing disability review if you're working continuously at close to the SGA level. I don't see any specific law on that, but again, I think that Social Security does things by using computer algorithms, and my guess would be if they see ongoing part-time work, the logical question is, if you're able to earn $1,600 in a month, how much more effort would it take to get to $1,620 or $1,690? And that might trigger them to at least ask the question. So I tell my clients, if you're working, go ahead, but I don't think you ought to be right close to that limit. And I think if at all possible, you shouldn't have the same monthly number every single month, because again, it looks like it's sort of staged. I think you also need to be aware that if you're getting paid biweekly, there are, I think, 3 times a year where you get 3 paychecks, and that could put you over the limit. So you have to be really, really careful about that. And there's not really any real-time reporting on this. I mean, there is a website now where you can go and you can report your earnings, but there's no way to see where you are in the process for the trial work period. So you have to kind of keep your own records. But I think I have seen the biweekly pay period thing trip people up, because they don't realize that they are getting that 3rd paycheck in a month. And let me move this down so you can people. Yes, another thing, by the way, that I'm doing now is well, let me just finish that thought. So the third paycheck can really be a problem if you're getting paid biweekly. Reason I just made that change on the videos because my streaming software, StreamYard, now lets me stream vertically. So if you're watching this on your phone or you're watching it on Instagram, you can see this in vertical as opposed to the horizontal that's being squished. And so this is the first time that's happened. That just came out this past week, which is kind of cool. So anyway, Corlil Katana says wave. Okay. I actually went to Tulane. Our mascot was the green wave. I don't think that's what you're talking about, but if you're waving, how you doing? Good to see you. Florida Raider fan, does the grid rule change affect current filings or just new ones? Again, nothing's happened yet. This is just all discussion. I think that in the past, when they've made a change, it has affected people that applied after a certain date. Doesn't mean they're going to do it this time. So if you have a current application, the old rules would apply to you. If you start a new application, so let's say the new law, if there is one, goes into effect, let's pick a date, July 1st or October 1st, cases are filed after that date, the new rules would go into effect. If you're already in process, the old rules would. That's the way they've done it in the past most of the time. Does that mean they're going to do it the same way? I can't say. I do tell people now, given that there's this discussion of a new rule, if you're going to file, if you're on the fence about filing, it might be worth taking a long look at it, because certainly when the new rule is effective, it goes into effect, any new rules that apply would be applicable. Those new rules will not help you. So it's probably better to have something in force already, maybe even get the case adjudicated before the new rules go into effect. That would even be better. But right now, we don't know. We just don't know anything about how they're doing it, what it's going to look like, what those new rules are. It's just ideas that have been floated. There are a couple of think tanks in Washington that for some reason have a real issue with Social Security disability, and they have the ear of the president. And, I think for political purposes, going after Social Security disability to save money is an easy target because there's not a big lobby. You go after retirement Social Security, you have the AARP, and the AARP votes, and they have a big platform to get their members to vote. And, they call it the third rail of politics for a good reason, because you start messing around with retirement, people get really, really angry. So, I think with disability, it's not as organized. And again, while the AARP will send out messages and things like that, it's not a priority for them, whereas retirement Social Security is. So I think that we don't have the same level of political punch that the AARP does have for retirement. Now, I will say that NOSCR, the National Organization of Social Security Representatives, they have a paid lobbyist who does meet with lawmakers, a former legislator who does meet with lawmakers and basically tries to educate them about what disability is and that it's not full of fraud and that people really depend on it for survival. NOSCR conventions, typically, they have 2 a year. Usually one of them is in Washington or close to Washington, and they actually have a day where members go and personally lobby their congresspeople. So, it is something that NOSCR is very, very aware of. And there are actually a couple of other organizations, NADER, which is more for non-attorney reps, and there's a new one, I can't remember the name of it, but they're all very focused on making sure that members of Congress understand what's going on. I've mentioned this before, but if we get the outline of a new deal or some sort of a new rule, I'll put something out there where I'll give you things to say. You can write your congressperson, call your congressperson, let them know that this is not a bunch of fraud. These are people that are legitimately, they've worked hard, they paid into the system, and they can't work. And when you're in that situation, don't play games with their survival, because it's really, I talked to somebody today, and if you don't have family that can help you, or either won't or can't help you, and you're by yourself, it's a really bad feeling when you've got no money coming in, and you can't afford to eat. And of course, this whole thing with this nonsense with the SNAP benefits, the food stamps, I just couldn't believe it. I mean, setting aside that it's a cruel thing to do. People that depend on food stamps to eat, you don't take away their food. Just politically, I just can't imagine that members of Congress would want to have to explain to constituents why they allowed, and that's not, forget whether they support it or not, why they allowed, they didn't try to work out a deal, which I think they've got a deal now, but why they would allow, the government to withhold food. I mean, that's just a terrible look. I know John Fetterman, the kind of maverick senator from, I think he's from Pennsylvania, he apologized. He's like, look, this was a failure by Congress, a failure by the executive branch. And I agree. I mean, it's one thing you can argue about a lot of things, government spending on, national parks, on roads, things like that, which, have necessity. But when it comes to people feeding their family, no, don't mess with that. I think that was a real miscalculation. Okay, Christy says, Christy's in Jacksonville. We've been to Jacksonville, a very nice place. Literally grandfathered in. Yeah, that's right. That's right. Whether you're a grandfather or not, you could be grandfathered in. Christy says, good evening. I hope your week is good so far. Yeah, actually, this week was kind of an interesting week. I didn't have any hearings this week. I had a couple last week. I've got a couple next week, but none this week. So I was able to use it to do some videos and to do some writing for some websites, and just to kind of catch up on a few things. So that was kind of a nice thing. And I've got a couple next week, and then after that's Thanksgiving. So I'm going to have a little time to do some work that I've really been putting off for a while. It gets busy again in December, January, but I'm hoping that this rest of this week and next week, and the week after, I can get some things done, which would be nice, because sometimes you got to just spend some time to think and to write and to recharge, and that's what I'm going to hopefully be able to do. Michael Irvine, hello from Philadelphia. How are you doing? I have never been to Philadelphia. I've been to New York, I've been to New Jersey. I've never been to Philadelphia. It's one place I'd like to go. I mean, I'm kind of a history buff, so I'd like to see, the Liberty Bell and Independence Hall and things like that. So hopefully I'll get up there, not in the wintertime though, but hopefully we'll be up there. I actually have a really close friend of mine is from there, and he gets up there periodically. So he's kind of giving me some things to see, but yeah, that would be something that would be kind of fun to do. Hopefully I'll be able to do it. Probably a lot more to see in Philadelphia than there's in Atlanta, where I live. Atlanta's a nice place to live. We have four seasons, a nice, topography, hills, and all that stuff. But there's not really a whole lot to see here. Not like it's a destination for a vacation. But it's a convention city, big airport. There are a few things to see, but it's not really someplace one would come to sightsee. But it's a nice place to live, and I'm from here, so don't plan on moving. Okay. Jerry Burden says, I'm 68. The appeals council remanded my SSDI claim back to the ALJ. What are your odds for approval? I think generally speaking, I think that, and I don't want to give you, I can't say absolutely. I will just tell you this. My experience, Jerry, has been that if the appeals council remands it, or a district court remands it, that's something that they only do if they think there was a fairly substantial mistake. Um, if they see a mistake, but it's what they call harmless error, meaning that it wouldn't have changed the outcome, they're probably not going to remand it. But if it's something that, is significant enough where they're going to issue a remand, they're basically saying to the ALJ, you screwed up, not just on this particular issue, but on the case as a whole. And so the message is you need to really look at this and really think about approving it. In my experience, about 2/3 of the judges that I've appealed cases and got remands on pick up on that sort of subliminal read between the lines message. There's one judge in particular that in the Atlanta area who's notorious for being very, very difficult. And I've gotten several cases remanded, and he has approved every single one of them. And that could be a statistical fluke, but I think that judges, they are evaluated based on performance. And when you appeal unfavorable decisions and the case is remanded, it's basically you made a mistake. And so, the judge is sort of being called on to the carpet on that. You made a mistake. And so, they want to keep their jobs and they don't want to be reviewed. So, it's no skin off their apple. They just would, okay, let's just go ahead and approve this case. And again, I've seen that again and again. Other judges, like, they say, well, it's remanded. I'll redo the analysis, but I may come out with the same answer. So, some judges are like, I don't care what the appeals council or district court says. I'm going to do what I'm going to do. Like I said, where other judges are like, I want to keep my job. So I think that, the chances of, if it's, first of all, it's back to the same ALJ or even a different ALJ, I think you definitely, things are going to be more favorable for you. Also, you're 68, which means that if you applied 7 years ago, you were 61. So anybody's over 60 has an advantage right away. So I think that when you combine the fact that you're, over age 60, which benefits you both under the grid rules and under the PALMS regulation about transferability of skills analysis, they've got to prove that you would have to make a minimum vocational adjustment, and the fact that you've got a remand, I think those are things that weigh in your favor. Am I guaranteeing you an approval? No, can't guarantee it. But I do think that the odds have definitely tipped more in your favor. Okay, just recently heard. Yeah, Chris, I just talked about that a little bit. There are a lot of rumors floating around that there will be a substantial change in the rules for Social Security disability, in particular, that age will be removed as a distinct factor, i.e. the grid rules. They want to either eliminate them or modify them. The thought is that age should not be a factor because more people are computer literate. There are many more jobs out there for people with a high school education, let's say, that are not physical. I'm not so sure about that. I mean, I know people in their 50s and 60s who are high school graduates who don't have any computer skills at all. And certainly if you evaluated, pick a number, 100,000, 200,000 people that are 55 or older, a higher percentage of those people are going to be, marginal in the computer versus people that are 25 or 30. Because, when I was and I'm in that demographic, when I was in high school, the computer we had had punch cards, and it was this huge, line printer thing. And you literally sat there, it looked like the size of a just a huge desk, and there was no monitor, there's no anything, and you put in punch card. I mean, it was very archaic. And I was pretty much an early adopter. I got my first computer when I was in law school. It was a dual floppy machine, and it was really slow and monochrome and everything. But I was the only one who had one. So I think that certainly people that are in their 30s and 20s grew up with computers and iPads and iPhones and things like that. But anybody over 45, not so much. So I think that this notion that people, in their 50s would be able to enter into an office environment, I think that's really wishful thinking. I just don't think that it exists. And again, I suspect that judges, both at the ALJ level, at the appeals council and district court level, recognize that as well. And it may be that, part of what we have to do in preparing for cases is, really develop information about the claimant or the client's capacity to do office work or computer work. And if you can prove that they don't have those skills because their education is more limited, or they submit a statement to the fact that their computer use is limited to email or checking Facebook, that may kind of minimize the effect of some of these new rules if they go into play. So what I'm getting at is that I think that the reality of life, that people over 50 or 55 probably don't have a lot of computer skills that could work in an office. That doesn't change what they change the rules. What we may have to do is go into some different types of proof and prove in our hearings that in fact people don't have these skills, and therefore we can eliminate some of those sit down computer type of jobs that really in many respects are not really unskilled. I mean, theoretically, a data entry job is unskilled, but you still have to have some basic level of knowledge. And it's hard to learn that if you've never dealt with it. So that's what we'll have to see. RD says hello from California. Hello, RD. Luke Rogers. Luke, I think you've made it before. I'm 44 with potential new change in age not being a factor. Help my case. I don't think anything new that they're talking about is going to help anybody, Luke. I think it's designed to make it more difficult to win. I think that what it's going to do is that we're a 44-year-old right now has to prove that there are literally no jobs in the economy that exist that you could do. I mean, even a simple entry level, packing items in a box. What the grid rules say right now is if you're over 50 and you're limited to, even if you could do sit down work, you're still disabled if you have no transferable skills. It's 55, even if you could do light work, which is standing 6 hours, lifting 20 pounds, occasionally you're still disabled. You get rid of that, basically you're saying you're putting everybody at 50 and 55 back into the same bunch, the same bundle as those in their 40s. So it's going to make it harder for everybody. Certainly people that are older, it's not going to really change what the requirements would be for you. It's just going to bring those other people who had a little bit of an advantage into your category. I have heard that, and who knows, that, mental health cases might be a little bit easier to win. I don't know why that would be the case, but it's a couple of the sources I saw said that, that might be a factor there, but I don't necessarily believe that. But again, I don't think that if you're 44, any new changes, nothing that's been done recently helps us win, no matter what your age. I don't think this will either. Okay, Christy says, if a job listing no longer exists, then why do vocational experts still use them in spite of being in the book? Very good question, and I'll give you two answers to it. First of all, Social Security has published a number of messages, they call them emergency messages, where they specifically say, here are 15 or 20 job titles that appear to be obsolete. And if you're going to use them, vocational witnesses, you've got to be able to prove through your testimony that they exist in substantial numbers. For years, when I started doing disability work, there is a job in the DOT called surveillance system monitor, where basically you'd be sitting at a table with a bunch of monitors in front of you. You see somebody breaking into a warehouse or used car lot, and you hit a button. Well, the reality is that job, when it's been studied, is not really an unskilled job, because you've got to know how to operate typically a computer terminal. You don't really pick up the phone anymore. You send an email. It's really more of a kind of a semi-skilled job. And a lot of those jobs also require the person to physically go investigate. So the point is it does not exist as a sedentary, unskilled job anymore. So Social Security sent out one of these messages saying, this job does not exist. Don't use it anymore unless you have specific evidence, which of course they don't have, that it really does exist. And there are a number of other jobs. I don't remember off the top of my head, but that's one that stands out. There are a number of other jobs in that same boat. So periodically they'll release emergency messages identifying jobs that do not exist in substantial numbers. I think, like I said, I gave the example of typewriter repair person. I think microfiche operator was one of them. I mean, there's a couple of these things that are really obscure. Some people aren't going to know what they even are. I mean, how many of you know what a microfiche is? If you don't know what it is, years ago, when before electronic storage, if you wanted to store documents, you would basically take a picture of them, reduce the picture to a very, very small size, and print it on like a sheet of film. And it would be literally it would be like in a file drawer someplace. It's called a microfiche. And then if you wanted to look at the document, you'd pull the piece of film out, which was about that big, about the size of an index card, and you put it into a microfiche reader, and it would magnify it. You could see it. I would dare say most people have never seen one of those, and they don't know. I don't think any libraries have them anymore. But it's an old technology, like an 8-track, if you know what that is. Microfiche handler or microfiche photographer, they don't exist anymore. So those are some examples of jobs. Now, the second part of this to answer this question is because the DOT is obsolete. There are other resources that vocational witnesses use, and there's flaws to this. But there's one called I think it's called the SOOC, Standard Occupational Characteristics, or something like that, basically of different jobs, and it theoretically identifies jobs, and it gives numbers to those jobs, and it's more of a recent type of survey. The problem is any one of those codes, there may be 5 DOT codes. So it's really hard to kind of figure out how many jobs a particular, occupation within the DOT has when all you have is a SOC code. So, for example, let's say that the SOC code just talked about 10 DOT codes. And the vocational witness says, well, this person could be a laundry marker, which is, SOC code 1234. But SOC code 1234 also includes 9 other jobs. And the total of those 10 jobs is, pick a number, 250,000 in the country. Well, can you simply divide by 10 and say that's how many, of any one particular job exists? You can't do that because, of those 10 jobs, one of them may be 90% of the jobs, and the other ones may be 3% or 2% or 1%. So it's a really flawed way to make that inference that because a DOT code is one of 10 SOC codes, that you can figure out how many jobs actually exist. Again, Social Security has given, I think, or the courts have given Social Security a little bit of a pass on this. So what Social Security did was they issued a ruling that basically says that the vocational witnesses have to explain where they came up with their numbers, and they all come up. There's actually a script they all follow. They use Job Browser Pro. They use this type of analysis, that type of analysis. You know what, folks? It's all just a big guess. Nobody knows how many, warehouse truck, forklift drivers there are. I mean, they can guesstimate, but nobody really knows. The key is, are there enough that they could say this exists in substantial numbers so that if a person has the capacity to do it, then, theoretically they're not disabled. In fact, that's why when you go to a hearing, the judge will always ask the vocational witness, give me 3 examples of jobs that a person could do. The thought being, if you get 3 examples of a person based on a hypothetical, which is a residual functional capacity description. So you've been described as being able to do light work. I'll give you an example. You can do light work, no climbing ladders, ropes, and scaffolds, no working in hazardous equipment or unprotected heights. And let's say then no use of the right lower extremity for foot controls. Let's say that's the hypothetical. Well, the vocational witness will come up with 3 different jobs and estimate the numbers for the 3 jobs. And so Social Security, the courts have basically said, if you come up with 3 jobs and the numbers in those 3 jobs are significant, whatever that means. And again, that's another topic for debate because different circuits decide on what is significant can mean. But the thought would be, if you have 3 jobs with fairly high numbers, that's basically saying Social Security has met its burden to say there are jobs that exist that you could do. That's the logic there. So if one job that they come up with is obsolete, I think many courts would say, well, there are two others that are not obsolete, so we're going to we're going to call it harmless error. However, sometimes vocational witnesses only give one job, or they give all three jobs are obsolete or very low numbers. That could be something that could be challenged. Like I said, I think that at this point, the courts have given Social Security a little bit of a pass, recognizing that there are no great resources to determine job numbers. They don't exist. So, what we're going to see if they change the rules is Social Security may become a little bit hard line. But right now, based on the regulations and based on the court decisions, they're letting Social Security get away with really guesstimating job numbers using, I think, flawed resources. I think that one of the repercussions of changing the rules, if they do, would be the courts will be less patient with Social Security guessing, and you may find attorneys challenging and getting a little further in court, challenging the numbers and the way they come up with these numbers. And all it takes is one circuit court to decide that Social Security's methodology is fatally flawed, and then you get to the Supreme Court, who knows what happens there. So it'll be real interesting to see. But right now, most vocational witnesses are smart enough to only use jobs that are not, have not been deemed obsolete. And yes, you can challenge the numbers. In my experience, challenging the numbers hasn't really gone anywhere. Again, I think most judges don't find that persuasive, and the appeals courts have not found it persuasive either. They, again, cut Social Security a little bit of a break. The only time it's been successful that I've observed would be if the vocational witness only gives one or two jobs and they're very low numbers, or two or three of the jobs are really, really, really low numbers. They might be open to it, but it's a hard argument to make. Not to say that there are some lawyers, some colleagues of mine, who have built their career on, basically cross-examining really hard the vocational witnesses. I don't find that goes anywhere for me personally, but there are some out there who really do. Teresita says, "Have a good evening." Hello, thank you very much. How do employee reductions in Social Security impact CDRs? What Focus Lady is asking is, with the government shutdown, there have been people put on furlough and laid off. I have not seen any statistics. I know that Social Security, even over the last year or so before the shutdown, they were at times putting a halt to CDR evaluations because they didn't have the personnel to do it. I've not seen anything to say that they've put a halt or a pause into CDRs because of the shutdown. Most Social Security employees are, they're fall into a category where the shutdown does not affect them. The place where we've seen the most impact is at the state agency level, where the funding, the way the Social Security works is when you file an application for benefits, Social Security takes the application, then they contract with an agency of the state where you live, Department of Health and Human Services, Department of Disability Adjudication. They call it, every state's got a different name for it, DDS, DAS, those are common names for it. And so the funding of these adjudicators is from the federal government. That money dried up. So I know that many states have had to put some or all of their adjudicators and state level staff on furlough. Although some of them, what I've read, as crazy as it may sound, that some of them, they're saying you've got to come to work anyway, otherwise you'll be considered to abandon your job, even though you're not getting paid for it. And there was some crazy article I saw the other day where I think some restaurant or some charity put together like a food train for Social Security employees, so they could at least have food coming in when they're having to work to preserve their job, but not getting paid for it, as crazy as that may be. But I think that there's been cutbacks in the state agencies. We're seeing definitely a slowdown in initial and recon evaluations. The other part that I know they slowed down or stopped was there are some personnel in Social Security that do fee petition evaluation. The fee petitions are where the attorneys get paid. Most of the time we do what they call a fee agreement. Our fee is 25% of past due benefits with a maximum of $9,200. The fee petition is another way to get paid, where if you can't do a fee agreement, for example, the client has had more than one attorney, or the case is unusually complicated, you can do a fee agreement or fee petition where you itemize your hours. The people that evaluated fee petitions are on furlough, so there's no action being done on that. They really don't care about them. So I've had fee petitions in process for years, probably never get paid on them. But that's one thing they put a halt to, which, by the way, I will tell you is, if somebody reaches out to me, and I've had a couple this week, and they had another attorney, the other attorney will not withdraw and waive fees. And the form that they would need to fill out is called the 1696 SUP2, SUP2, to withdraw and waive fees. If the prior attorney will not waive fees, I will not touch the case because there's no way for me to get paid. It's just unfortunate, but that's the way it goes. So, I think that fee petitions are not being evaluated at all. So that's another area. But other than that, the hearing process goes on, the appeals council, that goes on. It's just some non-essential offices or workers in Social Security are not being paid. And, it's not really changed much of anything other than at the state agency and the fee petition level that I've noticed there. So, so the bottom line is that I think with the CDRs, I've not seen anything to say that they're not still doing them, although I've not heard about as many of them being done, for what it's worth. Why? This is a great question, Christy. Why is SGA less than the amount you need to earn even one work credit? How do they calculate these amounts? That is a very good question. In fact, I've got a page. Let me pull it up and I'll put it in the comments on my website, one of my websites, I called it Social Security's confusing and inconsistent table of numbers. I'll put a copy of that into the comments here. And what Christy's getting at is that the amount for SGA is different than the amount for an earnings credit. It's different for the amount of for a trial work period. I have no idea why these numbers are different. It makes no sense to me. Look, I'll tell you the big one, you didn't ask about it, but I'll tell you, I did bankruptcy work for a number of years. And one of the metrics that we used in bankruptcy work was median income. In other words, to do a Chapter 7, which is where you wipe out debt because you have no disposable income, you have to show that your income, your household income, is at or below the median income table for your state. So let's say that in any state, the median income for a family of four is like $75,000 a year. Well, as I mentioned, SGA is $20,000 a year. So you have on one hand, the U.S. trustees and bankruptcy are saying that you're basically broke if you're earning $75,000 a year, given the normal expenses that people have. It's good enough to qualify you for Chapter 7, but it's not. But you can, you basically earn a third of that, 25% of that, and you're considered to be working for Social Security purposes. Absurd. It's absolutely absurd. But again, Social Security is the disability part is the redheaded stepchild of the Social Security Act, and so they get away with it of deciding that even minimal less than survival income is somehow substantial gainful activity. It clearly is not, and if it was, then why are you able to file bankruptcy and you could earn 4 times as much? I have no answer for that. So there is no really good answer to that, Christy. I just think it's just one of the things there. It's one of the things that they do. They get away with it. Okay. This case says, do I need to let SSA know if I've made only $60 from a TikTok video? I know that there's some reporting There's a website, I don't remember what it was, but you can look it up, where you report your income. They're not concerned about $60. They're concerned about people making $1,000, $1,500, $60, $100, $500. I don't think it makes a difference. Look, Social Security gets your earning statements, your tax records. So if you got I don't think you would get a 1099 from $60 from a TikTok video. So I don't think it's something to even worry about. Keep your records so that if you ever ask. But I don't think that earning, $200, $300, $400 a month is enough to make any difference whatsoever. Could you report it? Yeah. Would I tell somebody to spend their time doing it? No, because it really is not going to make any difference at all. Maureen, another regular. Maureen, how are you doing? Good evening. Good evening to you. SA, one of my regulars too. Psychiatrist has recommended I have my genes tested for treatment-resistant depression. Any thoughts? Yeah, I've used those. I've used that before. I've used genetic test records. They are considered an acceptable medical source. And so, yeah, if you have a genetic predisposition to treatment-resistant depression, I think that is very relevant evidence. Yeah, absolutely. Absolutely. It's amazing, nowadays what they can find out. I mean, I don't know if any of y'all have done like 23andMe, which got in some trouble for data leaks, but there's Ancestry.com, there's Family Tree DNA, all these things. And I've done several of them because I'm kind of curious about that stuff. But, I know on 23andMe, they can give you a report whether, certain diseases that you are more likely to be susceptible for, whether you're likely to have, I guess, what is it? One of them was that you would flush with drinking alcohol, or that you might be more inclined to abuse alcohol. Others that you might be more inclined to burn as opposed to tan. I mean, it's really interesting. And some of them, like one of them said about me that I'm likely to have more fast twitch muscle fiber than the average person. Like, have you seen me run? Have you seen me play tennis? I don't have fast twitch muscle fibers. My cousin got them. My stupid first cousin got all the fast twitch muscle fibers. He played pro baseball, but I didn't get any of them. So, but I got the good luck. So it's too bad for him. But anyway, yeah, I'd say that genetic testing is definitely a viable thing to do, and I would definitely look at doing it. It may be very useful evidence for a judge. An essay says, does your insurance cover it? Probably not. I'm guessing it would not. But again, you might ask, maybe it will. Okay. Kimberly, although, and Christy points out that genetic testing can be expensive. Yes, but I think it's getting less expensive as time goes by. That's one of these things where I think, getting genetic profiles is a lot easier, a lot less expensive than it used to be. Kimberly Kane, if I was working part-time on an SSD under the monthly limit that requires to report what we earn, yeah, I think they probably, my microphone fell off. Yeah, I think they do want you to report it. Again, I think there's a portal out there someplace. I'll have to find that. If anybody knows, post it, the portal where you report your earnings. And when you say under the monthly limit, there are two monthly limits you got to be concerned about. One is SGA, that's the big one, but trial work period, because you can have up to 9 months of over trial work period earnings without affecting your disability. If you're under the trial work period month, which I think is $1,160, let's see here. Let's see, $1,160. It's going to go up to, I think, $1,190 or something in 26. But in 2025, trial work period is $1,160. So if you're earning $1,100, you don't, you're below trial work. Now you still have to report it, I believe, but you wouldn't use up one of your 9 months, which is useful. So that's an area where I think you can sort of play with the numbers a little bit. So you can do everything you can to keep your earnings below the gross earnings below trial work period, so you don't use those up. So in case you do go over them, you have 9 months where it won't affect you. Okay. Is it permissible, says Roy, for a disabled person to return part-time under 1620 to their previous? Yes, it would be. It doesn't matter previous or current or or former or new employer, it doesn't really matter. Yes, you can return part-time under the SJ amount. I just would be careful about not going right below it. 16, 19 wouldn't be wise, I don't think. But yeah, you can go back to going to the same employer is not going to, I don't think, make any difference at all. Cynthia, I've been 7 months, as you know, in recon. Why no adjudicator has been assigned? They only speak to my attorney. Yeah, that's pretty much right. That they will only, if you've got an attorney, they will only speak to me. And as far as why they haven't assigned it, is because this is again where the shutdown has created a problem, that the money to pay those adjudicators is dried up. There's no money to pay them. So I think that's really slowed things down. When the government shutdown is over, I think we'll start seeing that pick up. The other thing is, in many states, the adjudicators are so overworked they can only handle a certain number of cases. So what you find is that Social Security, keeps these cases. Well, I forget what the term they use. There's a term they use for it, but the cases are kind of in a holding pattern until there's room in the adjudicator's office to actually do the evaluation. So I've had a number of cases where the file, the client in Texas in particular is a really bad one, where the file is basically sitting there in limbo. No one's even looked at it until 8 or 9 or 10 months or a year later, and that's just because they don't have enough staff. That's or the staff is too busy. Can the public go to the NOSCR conference only for legal representatives? You have to be to go to the NOSCR conference. You have to be a member of NOSCR. I think, I don't know if NOSCR allows it's not cheap. It's a couple $1,000 a year or something like that. I don't know. It's not maybe not quite that much, but it's $600 or $700 a year for membership. I don't know that a non-attorney or somebody not in the Social Security, I know you don't have to be an attorney, you could be a disability rep, can belong to it. I don't think you can go to the convention, I don't believe, unless you're a member. And the conventions are a couple $1,000, so not a cheap type of thing. I don't know. It's NOSSCR. You can go to their website, nosscr.org, or NADR and nader.org. You can look up and see whether you could buy, the copies of the information. I just don't know. Honestly, just don't know. That's just one of these things where I'm not. I just don't know. Okay, but my guess would be you probably wouldn't get a whole lot out of it, because I'd say about half of the programs are designed for new lawyers that are kind of getting into it. The other half is a little more for people who've done this for a long time, and it gets into kind of the weeds about stuff. And if you're not familiar with the area of law, it's designed for lawyers or people doing this type of stuff. It's not really designed for the public. But you probably wouldn't get a whole lot out of it. But there are certainly I've gone to a couple of them, and it's always interesting. Honestly, for me, it's more the networking. I mean, you always can learn something. I don't say I know everything, but a lot of the stuff they're talking, I don't need to know what SGA is. I don't need to know how to conduct a hearing. I've done thousands of them. So some of the stuff there is kind of elementary. If you've done this for a while, there's obviously and there are also a number of the programs get into very, very sophisticated cross-examining the VEs and using how to cross-examine Job Browser Pro, and some of the stuff I just think is it's rearranging deck chairs on the Titanic. Just my opinion, but so I don't know, but I don't know that an individual would get much out of it. All right, for those of you on TikTok, I'm sorry, not on TikTok, on Instagram, I think this will cut off in about a minute, because Instagram only allows for an hour. I'll see if I can figure out how to get it started again. I see a few people on Instagram, and again, now it's got the the vertical feed, so it does work better for Instagram. So if you do get cut off, I'll see if I can figure out how to get you back on very quickly. If I can't, then you would need to go over to YouTube or Facebook and continue to watch. Just go to my YouTube channel, Ginsberg SSD. You could continue to watch. So, but if I can get it back on Instagram, I will. And we're starting to do a little more work on Instagram. So I probably will take parts of this, cut it up, and put it on Instagram. So you may see more of that. My Instagram channel, by the way, is Ginsberg. What is it? The Ginsberg Law Offices, Ginsberg, Ginsberg Law Offices on Instagram. So please follow me there. So right now it seems like it's still going. So we'll see if it does. I don't know if it stops or not. Okay. I'm looking at my screen, by the way, because I'm looking at the Instagram feed. You have to kind of manually do it. And so right now it's still showing it's working. So we'll see. SA says that the $300 with insurance for the genetic testing. Yes, that is expensive. That is expensive. Okay. Amazing Grace Ranch. I just received my SSD. I review paperwork. How long does it take for them to give an answer? Okay. Instagram is disconnected. Okay, let me remove the destination. I'm going to go ahead and try to, if you bear with me, I'm going to remove it. I'm going to go ahead and re-add it back in so we can keep on Instagram. Let's see here. And let's see in the live video. Bear with me for 1 second. And let's see if we can figure out how to do this, if it will start again. I got to get the stream key. Okay, I don't know how to do this. All right, so I'm going to go ahead and you know what? I haven't figured out how to do this yet. So what we're going to do is next time I'll be able to get the second hour for Instagram. But for right now, we're just going to continue doing it on Facebook and LinkedIn and YouTube. But I'm trying to learn how to do it. I just want to make sure that we save the Instagram feed. I don't know if I saved, I don't know. We'll see. Do some of the archive on the Instagram app. Okay. All right. We'll figure that out later. All right. Let's see what we got here. Hello, sir, says Nick Mencia. Hello, Nick. Can you see the barracks that Washington, if you go to Philadelphia, that's what that's about. I don't know. Good question. Hello from Northern California. Can you talk a little bit about how people are supposed to support themselves and their family while applying for SSD? That is the big question, David. That's the $10,000 question. There is no answer to it. I don't know how you're supposed to survive. $20,000 a year, if you can find a job, not a lot of money. I tell people when they apply, the best case scenario would be that they may get a decision in 7 or 8 months. It could be approved. Otherwise, you got to wait 2 to 2.5 years. I would talk to your friends and family before you apply. If you've got any savings, if you can figure out a way to live very inexpensively, there just is no good answer to that. There's no way to really tell you. I mean, it's just ridiculous. I mean, what I tell people to do is after 5 or 6 months of waiting, contact their senator and ask the senator for a congressional inquiry. That will speed it up a little bit. That's about the only thing I can tell you. Let's see here. Maybe I can. Let me just see if I can do this. I'm going to try the Instagram thing one more time. Let's see if I can make it work. I apologize for. Let's just see if we can do it. Just because I want to learn how to do it. All right. Let's see if this works. But anyway, as far as how to survive, there is no great answer to that. No great answer to that at all. Christy says, I'd love to move to Atlanta because our public transportation is better than here in Jacksonville. Christy, honestly, our public transportation is not. Oh, here we go. I'm back on Instagram. Look at that. Okay, cool. It's not great. We have a public transportation called MARTA, Metro Atlanta Rapid Transit. It's not great, I'll tell you. I mean, it may be better than Jacksonville. Atlanta's very, very spread out. There's really no natural barriers. There's not like a ocean or river, anything like that. And MARTA really is kind of limited. It's not particularly well run, and doesn't go that many places. And the density of the population is not great enough to really allow them to run the trains and the buses on a regular basis. So, and there's been a crime problem with it. I mean, when I was doing live hearings in downtown, I would get on the MARTA train at Dunwoody, which is near where my office is. I'd go downtown, but the trains only ran after rush hour every 20, 25 minutes. And there was really no way to know if the train was running on time. And more than a few times, the trains, there'd be a breakdown someplace and they wouldn't run at all. So I wouldn't move to Atlanta. There's a lot of reasons to move to Atlanta, but MARTA, public transportation, ain't one of them. So I don't know what Jacksonville's like, but you really need a car in Atlanta. Okay, so Christy says, here's a link to Gene's site. Andrea, I owe you a phone call, Andrea, and I know that. I'll do it. I mean to do it today, and I just couldn't. They got past me because I know we have to talk about onset issues here. Semi-updated work history for my 20 year was not considered because I put 2-month work attempt outside my field. Well, they're going to look at, and let me just see, so I can tell you specifically. They will look at, let's see, we don't have a hearing date at this point in your case. All right, so they look at the 5 years prior to the hearing. So let's say if you had a hearing in 25, which you won't, but let's say it was in 26, they would be looking at 2021 to 2026. If you have not worked SGA level since before 2021, then there will be no SGA. So, the work history form, I would just fill it out. I know in your case, I know we've got to talk about some other things, and we can discuss that in a phone call. But the work attempts, you would put them on the work history form, but you'd put how short they were. They won't count. In fact, when I'm looking at a file, the state agency, in your case, the California agency, is going to look to determine whether your past jobs are SGA level jobs. And so they will make that determination. We can challenge that, but they will typically make it. But it's going to be basically 5 years, subtract the hearing from 5 years from the date of the hearing. And we're not even close at this point to you're at recon. So we're not going to be doing a hearing probably for another year. So, at this point, I would still fill out the form as accurate as I can, but they're going to really be focused on the last, let's just even say 5 or 6 years. But answer the form as best you can, I would say, and send it in, and I'll take a look at it. Certainly, we can talk about it. And I apologize for not getting back to you sooner because I've got that on my list to do. So we'll try to do that tomorrow. Heavy beverage. So your job is probably going to be a medium to heavy job, and probably semi-skilled would be my guess. Okay. It seems so crazy with AI taking over so many jobs in the English-speaking population. The layoff data has skyrocketed. I don't know that AI has taken over so many jobs. There are jobs that AI has taken over. They tend to be more of the, coding, more, computer type of things, maybe some clerical type of things. Like there are applications like WhisperFlow where you can literally talk to your computer. There are other jobs that, summarize medical. I think certain, administrative tasks can be done by AI. But I think we're at the very, very beginning. I think that AI is just starting to have its effect on things. I mean, it's going to affect lawyers. I mean, they're already, I mean, everybody's heard of like LegalZoom, things like that, which are not really AI tools. But you can go to Chat GPT, and I'm playing around a lot with some of these tools like Chat GPT. I'm in a mastermind group with Chat GPT and Perplexity and Claude and Notebook LM. And there are certain analytical functions that I would do or have someone in my office do that AI can do. I use, I mentioned this before, I use, and if you're interested, check this out. The one I use is called Notebook LM. That's one I use most of the time. It is a Google product. I use the paid version because the paid version, you can basically say, do not share my data. So basically the only thing it will look at is what I give it. So like when I'm doing a hearing, I create an account, or I create a folder on Notebook LM, and I upload, various bits of information, and I can have it do some basic tasks for me. And it's, again, just it's private to the extent that anything's private nowadays. But if you do the public version, the free versions, they train on the data, so you want to be careful about that. But certainly I tell people, go to Chat GPT or Perplexity or any of the AI tools and say, what are the questions I'm likely to get at my hearing? Or what are some good strategies for winning a back pain case at initial application? It won't be perfect, but it'll probably tell you something you didn't know. In fact, I did that. I posed a question. I uploaded a lot of questions over the years. I've written down when I hear an interesting question a judge asks, I put it on a file. And so I uploaded, I've gotten another attorney sent me questions that she had done the same thing. So I uploaded all that to one of the AI tools and said, create a document setting out the categories and the questions that a person's likely to get. Let me tell you, it's pretty darn good. And so I send it to my clients, and that's what we use. We do our pre-hearing call. We go over that, and I'm going to have to update this and make some changes to it, but it's 95% there. So that's a use of AI. So I definitely would say it's worth taking a look at. And it's something that there's a number of other lawyer-specific AI tools that people are using to do medical summaries. So it's going to take over a lot of jobs. There's no question about it. I mean, I suspect if you wanted a simple will, go to Chat GPT. It'll draft up a simple will. It'd be probably just as good as anything a lawyer could do. So the real issue with AI is what they call hallucinations, where the AI tells you what you think, what it thinks you want to hear, or they compliment you about how brilliant your question was, and it gives you complete BS answers. And I've seen that a couple of times where I'll ask it a question and it gives me an answer that sounds really good, but it's wrong. So you got to be careful about that. But isn't that true with the internet in general? All right. Essay was asking about the genetic testing. Does anybody have any experience with that? That's a good question there. T. Lux, good evening, T. Lux. How are you doing? Sharon, how are you doing? You got it, Sharon. Good to see you. Hope all is well with you. Luke Rogers, remember using these microfiche? Okay, looking on newspapers. Yeah, it was very cool. Yeah, microfiche is it's actually FICHE, not FISH, although it's both about the same at this point. But yeah, it is kind of cool. I remember when I went to a debate camp. A lot of people who are lawyers do debate in high school where I don't know if this may be, I won't go into much detail, but every year there's like a national organization, I think it's out of MIT or something like that, that comes up with a topic, and then they send it out to all the high schools and for debate teams. And what debate teams do is you take the pro and the con of a particular thing. The pro ought to be that the United States ought to eliminate all nuclear weapons, or there ought to be a world organization to deal with hunger, or it could be any number. It's typically not real controversial, but it's something that is very, very big picture. And so you have to take one side or the other, and you have to get evidence, ideally from quotes from experts or research, or it could be articles and things like that. Then you come up with your argument and a plan to affect that particular, let's say if it's how to eliminate nuclear weapons, and the reasons why we ought to, And then there's another side that says, no, we should never do that. So before the debate, they, I don't know if they flip a coin or they just decide, okay, you're on the pro, you're on the con. And so you may have, in one debate, you may be for the topic and the next one you be against it. You've got to be able to defend the status quo or talk about, offer a counter proposal. It's very, very formalized, but it's really interesting because there's very specific time limits. It's been a long time since I did this, but very specific time limits, but you learn to, research, think on your feet, make arguments very clearly in a very short period of time, respond to, other arguments. So it's really good training for lawyers. And so I did it. Emory University had this thing, I think they still have it, called the Barclay Forum. And there was a woman there who did this for years and years and years. And when she first started is when I went. She just retired a few years ago. But it's the reason I got off on the tangent was some of the resources we used were on microfiche, and so that's when I learned how to use it. And again, you go to a library, and at the time, Emory had a very really sophisticated library with a lot of great stuff you couldn't find anyplace else. It was closed. You had to have a card to get in there, but they had a lot of old data on microfiche, and that was where I used it. So again, completely irrelevant to anything at all, but it's my live stream, so I can talk about it. Okay. Yeah. And Captain says it's one big Dungeons and Dragons game, and the judge is the dungeon master. Yeah, to some degree. I mean, judges have a lot of leeway. I think that what I try to do is make my argument, get evidence I need, so that the judge, really has to work hard to deny the case. I've had judges tell me, make it impossible for me to turn this case down by giving me, all the information that I, that the appeals counsel would say you're not being reasonable to turn this case down. But yeah, it is it's somewhat of a game, I'll tell you. Okay. We have 4 to 5 Sports. Good evening. Hello. Okay. What if the gene site, that's the gene essay, is asking about genetic testing for treatment-resistant depression. What if genetic testing comes back normal? You don't want it used against you. I would say this, under Social Security rules, if there is evidence that you have possession of, you're required to submit it. I think with genetic testing, the absence of a gene showing your susceptibility to treatment-resistant depression is not evidence that you don't have it. I think, in other words, if the gene is there, I think that's evidence you can use in your favor. If it's not there, you could still have treatment-resistant depression without the gene. So it's not inherently a genetic thing. Now, there are some diseases that are genetic, 100%. Treatment-resistant depression is not one of them. So I don't think that if you got tested and it came back that you are not genetically predisposed to treatment-resistant depression, I don't think that would hurt you. So I wouldn't worry about that. Okay. All right. Maureen says, yes, you have to report your earnings. If you don't, they'll scold you and ask for wage records from your employer. I think they ask for the wage record, or they get them anyway, because it's it's part of the IRS stuff. Maureen, maybe you can answer the question. Is there a portal? Maybe I can Google this real quick. Where do I report? Do I report earnings to Social Security if on SSDI? Let's just see if it tells me. Report changes to work and income. It says do it through your MySSA account. So you'd go to ssa.gov/myaccount, and I think that's where you'd report them. Your My Social Security account is where you'd report them. So, yeah, Maureen says go ahead and report them. I think that's probably good advice. I'm still not sure that $50 would be worthy of that, but if you want to be absolutely safe, go ahead and do it. At the end of the day, I don't think you're going to get in trouble for not reporting earnings that are well below SGA. But I think that the issue is if you're over SGA, you get into overpayment status, not reporting the earnings will delay them finding out, which means you're going to be in overpay a lot more when they find out that you're going to owe a lot of money, is what's going to be the problem. Amazing Grace Ranch. Who's I can know according to this you're watching on a phone. That's very interesting. They changed the StreamYard a little bit here. What is SJ amount? I didn't know you could work part-time. Okay, so again, if you look at that link, and let me put this in again, and you can look for SGA and trial work period. I'm going to put this in again, Amazing Grace Ranch, and you can see the current tables. So, SGA in 2025, 1620, it'll be 1690 in 2026. The trial work period in 2025 is 1160. I don't know what I'm not sure what it is. Let me see if I can tell you what it is in 26 is going to be 1210. So it's going to go up, about $50. So, I think you need to be aware of both those numbers. But the SGA is the more important one, in my opinion. What I recommend is 65-year-old to apply for SSD. I just signed up for their Social Security. The amount that you get is going to be about the same. If you get full retirement or Social Security disability, it's pretty much the same amount. The issue with SSDI is it could take a couple of years. So, what some people do is they go ahead and get their retirement, and then if they take early retirement, they can file for disability for the difference between the two. If you're getting full retirement, just do that. That way you don't have to go through the 2-year wait. So I think you're pretty close to full retirement age. I would probably tell you just to wait. I think it probably makes more sense. Because honestly, from my perspective as an attorney, I get paid a percentage of past due benefits. If somebody is getting early retirement and they're getting $1,200 a month and their full retirement is $1,500, that's $300 difference. I get paid 25% of that $300 times however many months it is. Not a lot of money. So, there are some cases I won't take because it's just not, I would lose money on them. If you're 65 and you took early retirement, you're going to be probably 90% of full retirement. There's not going to be enough of a gap there to justify getting it for most attorneys to want to get involved in it. So my thought would be save yourself the hassle, just take early retirement. When you get to full retirement, take that if you can swing it, or go early retirement now. And the difference between that and full is not going to be that great. Go to your my Social Security page, ssa.gov/my account, and that way you will get you can see what your monthly payments would be if you took it now versus taking it at full retirement. Okay, Maureen, confirm that. Enter it all in your My Social Security account. It's very user friendly. Good to know. I'm glad you told me that. But that's exactly where you would do it at My Social Security account. Okay, SA has migraines and ear neuralgia. Your brain MRI is normal. That's one of my concerns. Not taking the gene test yet. Again, that's a judgment call you got to make. I still don't think it's going to hurt you, because if it comes back negative, that doesn't mean you don't have treatment-resistant depression. All right. My family, all kind of weird. You have this really schizophrenic brother. Could be. There could be some genetic stuff going on there. Could be. Okay. Okay. If you work at all, can't they take your SSA? They have to, again, if you work, first of all, you have to use up your trial work period months. So when you're in the trial work period time, they will not cut you off at all. Then as long as you stay below SGA, you're pretty safe, even if you're working. Where I think you run into trouble would be if SGA in 2026 is 1,200 and what did I say, 1,200 and boy, 1,209. I'm sorry, 15. What am I? I'm losing my mind here. Let me get to the right numbers here. $1,690. Okay, if that is SGA in 2026, if it's, let's see here, 1620. I'm sorry, 1620. All these numbers confusing me. 1620, 2025, 1690, and 2026. If, let's say in 2026, you're earning $1,689 a month after month. That's an exaggeration, but that's my point. They're going to think you're manipulating the system. So working and earning really close to SGA month after month, in my opinion, is problematic. If you do it and your income kind of jumps up and down, and most months it's $1,200, $1,400, I think it's less likely it's going to hurt you. They don't want to discourage people from working. They just don't want people playing the system. I think SA answered this. No, I don't think so. A good question. Is SGA level payment the same in every state? How about explain? Yes, it is the same. And that's, again, a very good question because, again, in bankruptcy, the numbers that we use for the means test in bankruptcy do change based on the state. So at this point, SGA is exactly the same in every state. So you could be in New York City where it's really expensive to live, or you can be in, rural Iowa where it's not so expensive to live, but SGA is the same. And in my opinion, that's kind of ridiculous. But then again, nobody asked me. But if they did, I would tell them. Bella Italian. Remember, there are 100 plus conditions of compassionate allowance. It can fast track your SSDI. It can. And, if you look up compassionate allowance, you'll see the conditions that are on there. These are listing level conditions, diseases, let's say, that are genetic diseases, that, Huntington's disease. There are, certain cancers on there. Compassionate allowance for life-limiting diseases. You've had a massive stroke and you're nonverbal, or you're in a wheelchair, or you're in a, hospital bed. It's pretty serious. These are not, simple conditions that are just, something that you're going to see on a frequent basis. These are life-limiting conditions. So it's a subset of the listings. It's like, if the listings are hard to meet, compassionate allowance is even harder to meet. So it's not that common. And when I see them, quite frankly, I'll get people call me sometimes, or they'll email me and they say, I've got terminal stage 4 cancer of the brain. I need to apply for disability. I, a lot of times, just take those cases and do it not for a fee. It's just to get it done. And a lot of my colleagues feel the same way. We'll just get those cases filed. And even though there won't be any fee, we just do it because it's the right thing to do. And I think it's not me. It's a lot of attorneys do that too. Or you could just, sometimes I'll give people the wording to use, and I'll just say, file the application, use this wording, you'll get approved, and they almost always are. But compassionate allowance are hard to win. Muley, does SSD have to say whether to approve you until you turn 55? Does your records tell you? When they issue a decision, whether it's an initial or recon or a hearing, there will be an explanation. Now, at the hearing level, the explanation will be in detail. At the initial and recon, they will give you kind of a form letter reason for denial that you can go back to your past work, or if there are other jobs you could do. But they don't tell you in detail why they approved you or why they changed the onset date. At a hearing level, they do. The judge's decision goes into detail about that, but not at initial at recon. So it depends on the stage you're at. Correct. Bella says that at full retirement age, your SSDI automatically converts to regular. That is correct. No SSDI at regular retirement. That is correct. It converts automatically to full retirement, and the amounts are about the same. RD. DDS, which is a state agency, has asked me if I've worked since my onset date, and the supplemental are asking for a second function report. Also requested a list of doctor visits. Is this a good sign or an appeal decision? I don't know that it would say good sign. It's just that somebody's working the file, which is what you want to see. So give them the answers quickly. Yeah, it's a sign that the file is being worked. I don't think it means that you're likely to be approved or denied. I think it just means that these are questions they have. Okay. Andrea is talking about past work. Then you said it was only 2 months. That would be an unsuccessful work attempt. Okay. My attorney said the judge wanted to look at medical more than a year back from the onset date. They said they can be upset that you gave them that. I kind of disagree on that, Muley. I mean, I think that look, the attitude Social Security has is your onset dates when you lost the ability to work. So most of the times when you stopped working. So theoretically, before your onset date, you had the capacity for work. So logically, medical treatment you got before your onset date, is marginally relevant. If you had back surgery 10 years ago, but you were able to work for the last 8 years, how relevant is it? I think it can be relevant in some situations. I'll give you a couple of examples. If you had, mental health issues as a child and you were in special classes, your high school or even elementary school records can be relevant, even though they may be 25 or 30 years old. If you had multiple surgeries, back surgeries, or any other kind of surgery, 10 years ago, and now you have scar tissue formation, it's relevant to know that you had the surgery. Now, many times that will be referenced in the record. What I do is if I'm submitting something that is 5 or 6 or 10 years old, I will usually attach an explanation as to why. Now, at the state agency level, they'll get it and they will, they'll review it and decide it's not really relevant. There in the electronic folder, there are 2 parts to it. There is the exhibit file, which is what they're working with. Then there's something called the unassociated file, which is everything else. And it could just be, letters asking for an address change. I mean, it could be basically it's miscellaneous, anything else. And a lot of times if I submit records that are, older, that'll end up in there. And where that can be useful would be, and I won't say it's a lot, but a couple of times there have been people I've represented and they're talking about some procedure they had a number of years ago that has gotten worse. And the judge will say, well, I don't see any record of that. And I'm like, well, Your Honor, it's in the unassociated part of the file. Social Security decided not to include it. And the judge can go in and pull that out and say, now that's part of the record. So I think if it's relevant, I'd still submit it. I'd still have it. But I think be prepared to explain why. Look, you are applying for disability. You have the right to make them or ask them to consider anything you think is relevant. And, they ask for all records that, no matter good, bad, or indifferent. So I think you have the right to submit whatever you want to submit. You want to avoid duplication. And, I don't know that your records from your pediatrician are going to be all that relevant that, you had the mumps or something when you're 4 years old, but, anything that's somewhat related to your condition, back problems, epidurals you got in some sort of injury, I think that can be relevant. So I would not necessarily hesitate submitting that. That is just my thought. But I don't think they get mad at you. And I think especially if you can explain why. And look, I mean, as an attorney, if a judge ever said to me, why did you submit these records? I'll look them in the face or her in the face and say, because they're relevant. And here's why they're relevant. And, Your Honor, if you don't wish to consider them, that's fine. But I wanted you to be aware this person had 4 back surgeries, in the past, and that, scar tissue is formed. That's why, we're no longer a surgical candidate. Perfectly relevant. But you got to be able to have some explanation for it. Do you need to put in, records from 5 years ago that you got treated for a sore throat? Probably not. But, that would be a hard thing to explain why that's relevant. But things that are related to what you're going through would be. Bella says AI is going to create more mistakes, more CDRs, possibly. I think remember a few weeks ago I had this woman on, Linda, which is not her name, but she's an adjudicator who actually I saw on LinkedIn she got a different job with an insurance company, so she'll come back maybe with her real name and not be as concerned about, talking about Social Security stuff as she was. Yeah, it could be. I mean, AI is a tool to evaluate data. And, I know that Social Security, according to Linda, is using some AI, not particularly effectively right now. But yeah, they will use it, and there are going to be mistakes. There's no question about it. There will be mistakes. On the other hand, what I think will happen, and it may be 5 or 10 years from now, is that Social Security will have a lot of data about cases that judges are approving. So if you have an example of 300,000 decisions, and let's say you take out, the outliers, the judges with really high or really low approval rates, you could create a fairly, reliable indicator algorithm about what cases should be approved. And they may use that at some point down the road to approve certain cases faster, which would put lawyers out of business to some degree. However, on the other hand, we're running out of hands here. If they pay people sooner, means the trust fund is going to get depleted sooner. So I don't know, but I think that AI will eventually develop the capability to give fairly accurate predictions about what cases are, in fact, winning disability cases. The person is in fact disabled. So I think that is coming. May not be for a while, and it may be something they don't want to use because they want to, keep the process delayed. I mean, Spencer Bishens, who is a former Social Security employee, has appeared on this live stream, and he says, I think it's intentional they make these long delays. So who knows? Amazing Grace. All right, I received the review papers, which I expect how long to take. So you want to fill those back out, either long form or short form. It could be 8 or 9 or 10 months before you hear back. And either they're going to write you and say, we've decided that nothing has changed significantly, you remain disabled, or they may say, we've decided to move to terminate you, in which case you can appeal. You have 10 days to ask that benefits continue while you appeal, but then you file a request for reconsideration and appeal. So given that you're kind of on the clock, we don't know what the decision is going to be made, but start putting your medical evidence together because you may need to use it. Virginia, and by the way, I've got the crawl here. If you found this live stream useful and you find my work useful, please give me a positive review. That is very helpful to me, and I would really appreciate it. All right. Look at it says, my full retirement is 67, so SSDI is not worth it. Probably. Again, the amount that you would get at 65 if you took early is probably going to be 70%, 75% of your full, maybe 80%. If you can obviously hang out and work for another couple of years, even a simple job, that might be a better thing to do. But, by the time you get a decision or SSDI case, you'll be at full retirement age. So you'll be going for a couple of years of past due benefits. If you don't take, the early retirement, if you do take it, you're looking at the difference between the two, not a lot of money and a lot of effort for that. So, let's see here. Nathan Fraley. I'm 47, have RA, lupus, immune system compromise, and issues for about 10 years. Just started to apply 2 years ago. When the doctors took you off work and they denied me, what are your chances? I think at 47, it's an uphill battle. Anybody under 50 is going to have more of a problem. RA, it depends on how serious it is. Same with lupus. These are conditions that can be mild, moderate, or severe. Same with immune system compromise. It can be severe. What does it mean? What are the practical problems you've got? Do you have, because of RA, can you not grip anything? Is it in your knees that affects you walking or standing or sitting? It really depends on the functional issues that arise from these things. But in general, anybody 47 who's not yet 50, you've got to prove that there is no job in the national economy existing you could do. And there are some really, really simple jobs. there's one that comes to mind that they eliminated called nut sorter, where you're basically sorting, I think it was literally nuts. But I think I did a video a few weeks ago of a guy sitting there on an assembly line and watching a little, plush dolls come through, and the ones where the sewing was off, he knocked them off, took them off the line. There are some really simple jobs out there, and you would have to prove with medical evidence and opinion evidence from your doctor that there is nothing at all that you can do, and that's a tall order. And judges, if you got in front of a judge at a hearing, 47, you're not 50, so the grids don't apply. Can you prove that there's really nothing you can do? Maybe you can, but RA is objective. You can look at that. You can see the swelling of the joints. Lupus, you may have blood factor, but again, lupus can express itself in different ways. Immune system, what does that mean? Is our objective tests. So, my gut tells me, yes, it's potentially viable, but I think it's an uphill battle. That's what my gut tells me. I could be wrong, but that's what I'm thinking. You are welcome. You're welcome. 1620 right now. Yeah, with all these different numbers flying about, I just kind of lost my train of thought. But 1620 now, 1690 in 2026. Adam writes, 51, been off work since April, filed around August. Can you talk about a failed work attempt affects the case? Yes. Good question, Adam. All right. A failed work attempt is when you try to work and in the way the law is written, you can only, you're there less than 6 months. I always look at 3 or 4 months. I think, technically it's up to 6 months, but it's basically, it says that you tried to work, you could not do it, and you had to quit. If it's 2 or 3 months, I think it's pretty clear that's what it is. When you get beyond 3 months, sometimes I've seen judges suggest it may be another reason than your inability to do it. Maybe you got fired for some other reason, or the company went out of business or something like that. But if you're working and you only last 3 months and because of your symptoms, you have to quit, that's an unsuccessful work attempt. Does not count as SGA. That's number one. Number two, I think it shows your motivation. You're motivated to try to work. You would much rather be working. You hate the idea of pursuing disability, and you do anything not to be disabled. So I think it can really help your case, in my opinion. But for me, 3-4 months. I think beyond that, 5 months, 5.5 months, it may technically be a failed work attempt, or UWA, unsuccessful work attempt. Usually judges see the eyebrows raise a little bit, at least in my experience. So I'm more of a 3-month person. All right, my retro channel at a federal court appeal remand, 3 AC remands, different judges, same errors. Case go back to Brian Konoski for federal appeal. Should have been found disabled under 12.05B, which is a mental health issue. Pray for me. Yeah, it's odd that you would think that if it's been remanded several times, that the judges keep making the same mistakes, or that the judges aren't picking up on, hey, we're remanding this because we think you need to approve the case. But I believe 1205 is the middle. I'm pretty sure it is 1205B. Let's just take a look. Yeah, it's mental health issue. 1205 is talking about intellectual disorder. And basically what it says is that, you've got an IQ of 70 or below, or I think there's a couple of things. Basically, that that mental health wise or intellectual wise, your capacity to perform a job is significantly reduced per the listing because of very, very low intellectual capacity, whether that's something you're born with or because of a closed head injury. I don't know. But if you meet the listing, it's odd that you would have different judges deny you on the same mistake. But Brian Konoski is a very, very sharp guy. He knows what he's doing when it comes to appeals, and hopefully you won't need to use him, but he's a good man if you do. failed attempt to return to work. Again, it's still the same thing. It's called UWA, unsuccessful work attempt. So if you are not able to return to work, that's an unsuccessful work attempt or failed work attempt. The technical term is UWA, unsuccessful work attempt. Maureen, yes, and I talked about that earlier. We were talking about reporting earnings, and I mentioned that if your trial work period, you've got 9 trial work period months in any 5-year period of time, but if you get paid every 2 weeks, there are going to be 3 pay periods. In 3 times a year, you're going to have 3 pay periods. That can put you over trial work and or SGA, so you got to be real careful about that. Okay. I'm tired too. I don't know why. I took a long walk with the dog today, so maybe that's why. Are DDS adjudicators doctors required by SSA regs to review medical records prior as well as after AOD or DLI? They generally, and I've not seen any specific rules, and there probably are. I just haven't seen them because this is not something I would necessarily deal with. I think they have an obligation to look at records that are relevant. And it appears to me that somebody has decided, a court has decided that they're only required to look at records 1 year prior to onset. And with the DLI, I have not seen that makes much of your DLI stands for date last insured. And so, if your date last insured was, let's say, December of 2023, the question is, are records in 24 and 25 relevant? I think they are, because it goes to the question of whether you remain disabled, even if you have to prove that you became disabled before the DLI. So, again, I think that it seems to me that the regulations require at least 1 year prior to the onset date, but I can't quote you the regulation, but they are required to look at records that are relevant to the issue at hand. Okay. Hawk Assad is 55. If I file for SSDI retro to my AOD 124, how would the grids apply in a borderline? Well, okay, so you're asking very good questions, and several of them. So when you turn 55, the light grid applies. So it's not based on application or onset, it's based on when you turn 55. So if you turned 55 2 days ago and your onset date is January of 24, then you were, 53, I guess, in January of 24. Or you said 2014. I'm sorry, I'm misreading that. Okay, so if you file for SSDI retro to AOD of 2014, well, they probably wouldn't apply. The grids wouldn't apply because the grids only apply with one small exception as of age 50. So 2014, you were not 50, so they wouldn't apply at all. And assuming you meant 2024, they would apply at your 55th birthday. And the borderline age situation is one. There's a POMS regulation that says if you're within a few days to weeks or months of that age category, like 55 from 54 or 50, that they can. And I've done this several times. That a person who's 54 years and 9.5 months, we can say they're in effect 55 for grid rule purposes, approve them at age 55 as if they were age 55. That's how that works. So basically you're saying, apply the grids to me. I'm not quite 55, but I'm close. Now, again, I'm assuming you made a typo here, and you're talking about, turning 55 a year or a year and a half after onset. I don't think that's borderline age. I think borderline age is going to be 3 months, 2 months. I don't think you can get much more than that out of it. No more than, say, 3 months. I think that's really pushing it. Okay, so Andrea is saying that the Social Security made a mistake in saying that an unsuccessful work attempt was, in fact, a job, or they wrongly described the job. We will have time to address that in terms of basically describing your past work and arguing that Social Security wrongfully analyzed it. So that's something we can deal with the judge about. But that's good. That's one thing I would want to know. In fact, I talked to a client today. We've got a hearing coming up next week, and she had given me a full page rebuttal to some conclusions of a mental health consultative evaluator, where she said, this person said I could drive, all day long. I never said that. I don't drive. Or this person's the psychologist said this. That's not what I said. So you can rebut all this type of stuff. So if Social Security described your past work incorrectly, we can submit another detailed work description to more accurately describe it, or a statement using SSA form 795 describing your past work. Okay. About 10 minutes to go here. Muley says, thank you again. You are welcome. You're very welcome. I was recently denied, says Rackin' Crazy. I'm 60, have done the same job since high school. Denial letter so I could adapt to another kind of work. The grids only apply if you have physical limitations. If this is mental health, anxiety, depression, PTSD, schizophrenia, the grid rules do not apply. So if it was physical, and they're trying to say you could adapt to another kind of work. If you have transferable skills, they could do that. But the argument you would make, let's assume you've got back pain, knee pain, shoulder pain, but you did a job as a vice principal at a high school. Okay, you would have transferable skills to, semi-skilled or other skilled or semi-skilled work. So you would have to prove that because of pain, medication side effects, fatigue, that your transferable skills have been eroded. But it's not automatic. In other words, if your past work was not unskilled, it was unskilled, you just have to prove I'm 60 and, unskilled past work, limited to light work, and you win. So here we don't know either A, what RFC the state agency came back with, light or medium, we don't know. And the second thing would be, is your underlying condition physical or is it purely non-exertional like mental health? Okay. Let's see. Mark Turner went to a CLE, mental. They canceled the medical. I went a week later, they moved me to step 4 as the local office, bad or good. Moving to step 4 is a good thing. They're going to look, assuming step 4 is the same thing I'm thinking of as past relevant work, they're making a decision whether you return to your past job. So, Muley says my ALJ is 44%. Now at ALJ. If you've got $80,000 at issue, give it a shot. Is it likely the judge is going to deny you entirely? Possible, but not really likely. A 44% judge is not the type of judge who's going to, generally speaking, going to take a partially favorable and make it an unfavorable. He might basically do the same thing the state agency did and approve you as of whatever date they did or your birthday, whatever, but probably not going to deny you at all. So for $80,000, probably worth rolling the dice. Okay. I think that, I do. I do use it in my law firm, and we just have to be very, very careful about the privacy issues. So all the AI tools I use are, I make it very clear that the AI, I buy the paid versions of it. I'm never did the free stuff, and that you disallow sharing or training using your information. I'm still trying to figure out which ones I trust. And again, the only one I trust so far is Notebook LM because I know it's only looking at what I give it. But ChatGPT I've used for blog posts and for video ideas and things like that. And I'm going to look at some of the other ones. This is a discussion in my mastermind group about about AI is what can we trust? And in fact, the State Bar of Georgia just came out with some guidance on that, which came out yesterday. I have to look at that. So just got to be real careful because you got to be concerned about privacy. Viv filed for Social Security disability in February of 2024, fired from your job of 18 years. That ouch. In May of 21. Would a letter from your boss saying facts about decline. Yes, I think it would be. I think it would be, especially if you can tie it to your medical condition. So if you have a medical condition that puts you in chronic pain, and your boss is basically saying that Viv's performance declined. She appeared to be in terrible pain. She was not able to focus, concentrate. She made mistakes she never made before, and we had to let her go because her performance had declined dramatically since she started treating for this medication side effects or underlying symptoms. Absolutely, that's very, very helpful evidence. Okay. Yeah, now I can imagine this is getting really, really frustrating for you. How come some grid, it's all of them, not just some, all of them, you don't, the grids do not apply unless you have a physical issue. I think the reason for that is, and this is just conjecture, they were designed for construction workers, people that had done physical labor their whole life. They have no skills other than physical labor and maybe carpentry or plumbing or something like that, but it's still very physical. And the reality is Social Security recognizes a person who is limited physically is not going to be able to adapt to a office type of job. They don't have the training, the education, the temperament for it. That's what it was designed for. And so it's evolved a little bit. Now you can be a college graduate and use the grid rules, but it's only for physical limitations because you have to, it basically says if you have an RFC of light or sedentary, which are physical things, then you still are qualified for disability. They could create a version of the grids for mental health, but I don't expect to see that in my lifetime, but it could happen. Mark says I work in the coal mine. So for the understanding, yeah, I mean, that's physical, hard physical labor, Mark, as you know much better than me, and probably not a lot of transferable skills, I would say, outside the coal mine. So, okay, let's see here. We're getting close to the end. Let's see if I got any more comments. And, okay. Bala 2001 says the Department of Labor Unemployment has detailed letter about your termination. I don't know there's so much of a detailed letter. I know in Georgia, where I'm at, the termination notice can be quite vague. And it can just be, poor performance or lack of work or, general layoff. It won't go into detail. Now, if you challenge the unemployment and it gets into, I hate to call it litigation, but it gets into, some sort of a conflict, then the more detailed information might come out. Possibly, Andrea, can the mistake that they made, why don't we do this? I know I owe you a phone call, let's go over that, and I'll do my best to call you tomorrow. I'm pretty clear tomorrow, and we can talk about that, and let's talk about how to try to get that fixed. I don't want to talk about your case in particular, in a public forum, but I do owe you a phone call, and I will definitely talk about that. So, okay, we're just about 2 hours, so let me go ahead and end this. I do appreciate everybody's time here. Okay, so I'm going to ask one more question we've got. How is a single-sided unsuccessful cochlear implant considered? It basically would say that there jobs out there that you can do without the capacity to hear. There probably are, not a ton, but there probably are. I don't think you would meet a listing with one ear, but I think that there are maybe some jobs that exist you can do without hearing. So I think it would eliminate many, but not all the jobs. That's what I would say. Okay, let me go ahead and end this now. We're right at 2 hours, and I appreciate everybody joining me. We are, so next week we'll be here. I think the week after is Thanksgiving. We'll decide on that. But for right now, I'll see you next week. Thank you, everybody. I appreciate your attendance. Hope you got something out of this. If you found it useful, give me a thumbs up, subscribe, and I'll see you all next week. Thanks a lot.